Good afternoon. Today we're going to be discussing Schwarck v. Arctic Cat Incorporated. During this discussion, we will look at a brief company history, a summary of the facts of the case, a case analysis, and an impact that this case had. Arctic Cat Incorporated is a self-proclaimed leader in snow and other outdoor motor vehicles as well as gear. Formed in 1962, it went through various financial turmoil that culminated in a 1982 bankruptcy. At that time, Arctic Cat Incorporated was bought out by another company, which in turn was bought out by Techron in 2017. Since then, Arctic Cat Incorporated has shown on Techron's consolidated statements during the years in which this case occurred. Arctic Cat showed an increase of net sales for units of $22,072 between 2012 and 2013, and an additional $9,528 increase between the years of 2013 and 2014. What was interesting is that the financial statements during this time pointed out snowmobiles in particular had a sales increase of 2%, suggesting that the litigation was not a discouraging factor for consumers in the market for snowmobiles. This case included two women, Karen Schwarck, the driver, and her sister, Edith Bono. These two sisters were on a ride on their unit, similar to what was pictured here, and went to the end of a bluff. In order to turn around, a 3-point turn was necessary, and during the last turn, going from reverse to forward, Karen, who no longer heard the reverse alarm, accelerated. Unfortunately, the transmission was not in forward, but still in reverse, propelling the sisters backwards and off of the bluff. This accident proved to be fatal. The estate of the two deceased women and their husbands turned around and sued Arctic Cat Incorporated in 2013, as well as the merchants who sold them the unit. It was answered March of 2013 by Arctic Cat, who denied the existence of a silent reverse zone and stated that even if it did exist, the point of the alarm was to let others around the unit know it was placed in reverse, not to alert the driver who presumably placed it in the gear. Their argument and testimony was enough to cast doubt of the true cause and liability in the court's eyes, and therefore, May 1st, 2014, the court decided in favor of the defendants, Arctic Cat. Through a series of appeals, this was overturned in 2016 when the courts decided that the accident was caused due to a safety measure placed as a protection for consumers. It failed and did not sound for the entirety of the time that the unit was reversed. The case itself focused on products liability and breach of implied warranty. Products liability being the legal concept that those who make, sell, or lease goods can be held liable for the physical harm or property damage caused by those goods to consumers, users, or bystanders. Breach of implied warranty being the failure of the merchant or manufacturer to provide a product that was of proper quality and reasonably fit for the ordinary purpose for which such good is used. In this case, producing a snowmobile that sounded the alarm through the entirety of the reversed gear rather than stopping in the middle of it. The claim of strict products liability, as stated by Clarkson and Miller, is set forth on the belief that the consumers should be protected, that the manufacturers and distributors cannot escape the liability of a faulty product because they are not specifically listed in the contract with the consumer, and the aforementioned entities are better suited to bear the cost associated with the injuries, which is what the estate used to include the manufacturer and seller of the snowmobile. The argument set forth by the plaintiffs seems specious at best. The reliance of testimony stemming from an investigation on the snowmobile after a 40-foot fall down a bluff opened door to doubt. Trying to map out the sequence of events after the fact without any eyewitnesses failed to originally convince the courts that the validity of their argument against Arctic Cat Incorporated. The burden of proof that this fault was what led to the fatal accident was not met. The burden of proof being a standard that the plaintiff must prove in his or her case through a preponderance of evidence and convince the courts that their argument is the closest one to the truth. The cause and effect relationship between the act and the injury suffered did not seem, to my opinion, meet this level. The testimony included doctors stating that the driver was impaired due to her age. An investigation of the motor vehicle itself showed that it was still placed in reverse and no alarm sounded. However, the vehicle fell 40 feet and had an impact. This was still enough to prove the courts in 2016, the Court of Appeals in Michigan, that the plaintiff's argument was valid and Arctic Cat was responsible for the lack of alarm, regardless of the original purpose and intent for which the alarm was installed for. We see this case impacting what we now know as a standardization of the backup beeper, whether it be in snowmobiles, other motor vehicles, such as cars. It also brought forth to light a focus on consumer safety. We are a community that is quick to go through litigation in order to solve problems. Therefore, the focus should be on the customer to ensure that the company is not liable for any injury to the consumer or anyone around said consumer while using the product, good, motor vehicle. Yet, I would say that the liability cannot solely fall on the company, especially in events and situations that are deemed riskier than others. What should have also been considered, in my opinion, is the assumption of risk, which requires that there is a knowledge of the risk and the voluntary aspect, knowingly placing yourself in a situation that is more dangerous than average than everyday life means you assume the risks of that situation. Unfortunately, in this case, it meant that the driver and the passenger lost their life. Yet, they knew that the snowmobile was dangerous whenever they got on and went for a ride. Yet, Arctic Cat has learned from this mistake. In 2019, it went through a recall for approximately 1,700 units, stating that there was a suspension failure. It had to have been expensive. It was very intensive. But this case laid the groundwork for that focus on consumer and customer safety, which in the end means a safer world for those in it. Thank you so much for your time. I hope you have a wonderful rest of your day.